Does a new will override an old will? A will is a vital document for outlining how your assets will be distributed and ensuring your wishes are followed after your passing. But life changes, like marriages, divorces, or new additions to the family, often make updates necessary. So, when a new will is drafted, does it automatically override an old one? Understanding the legal principles of revocation and replacement is essential to avoid probate disputes. The legalities of revoking an old will in Georgia. A new will generally overrides an old one if it meets all the legal requirements for execution. A new will becomes the final statement of the testator's wishes, provided it includes a signature by the testator, or someone signing on their behalf under their direction. Two competent witnesses present at the same time during the signing. Evidence of the testator's testamentary intent and mental capacity. Including an explicit revocation clause is the most effective way to ensure the new will fully supersedes any prior ones. This clause clearly states that all previous wills and codicils are revoked, eliminating confusion and reducing the risk of disputes. Without it, the older will might retain partial validity, especially in cases where conflicting provisions arise. Georgia also allows codicils, amendments to existing wills, to make updates without replacing the entire document. However, codicils must follow the same legal requirements as a will to be valid. Despite their utility for minor changes, codicils can create ambiguities, especially if multiple ones exist. For clarity, drafting a new will is often the better choice for significant updates. How a new will overrides an old will. A new will automatically overrides conflicting terms in an old one if properly executed. However, issues may arise without a revocation clause, as beneficiaries or executors might attempt to argue for the validity of older provisions. For example, if an old will names an executor and the new one names someone else but doesn't address other aspects of the estate, the executor designation from the new will overrides the old. This creates a partial revocation scenario where both documents may need to be reconciled, complicating the probate process. To avoid such confusion, clear language and proper execution are critical. If the new will is invalid, whether due to missing signatures, lack of witnesses, or undue influence, the old will might remain in effect. That's why working with a lawyer ensures your estate plan meets all legal requirements. The process of drafting or revising a will. Creating or revising a will in Georgia requires careful adherence to legal formalities. A valid will must reflect the testator's intentions without ambiguity, especially when revoking an older one. It's also crucial to handle the old will properly to avoid future disputes. Destroying or marking it as revoked ensures it won't be mistaken as valid during probate. In situations involving significant changes, like adding beneficiaries, altering asset distributions, or addressing blended family dynamics, drafting a new will is more effective than using a codicil. It provides a clean slate for the testator's intentions, supported by an explicit revocation clause. If you're unsure about how a new will affects an old one, consulting with a trusted attorney can clarify the process and help safeguard your wishes. For personalized assistance with creating or updating a will in Georgia, contact Trace Brooks Law at 404-492-9559. Our office is conveniently located at 1275 Peachtree Street NE number 525, Atlanta, Georgia, 30309, where our team can guide you through the estate planning process with clarity and confidence.